Pontoon, maybe?
Good morning. Hang on just a second, I don't have your file yet.
She may be right, so I think she was in the same cell.
Okay. Before we address your case, I want to make sure you understand your constitutional rights. First of all, the right to remain silent. You don't have to talk to anybody today. This gentleman's with the PD's office, Public Defender's office. He's here to help you if you have any questions. We're gonna enter a plea, most likely of not guilty. Figure out your next court date, figure out your attorney situation. You do have felony charges, so you have a right to a preliminary hearing before a judge to determine if that crime was committed and committed by you. If you remain in custody, that hearing has to be held within 10 days of today, your arraignment. If you get out of custody, it has to be held within 20 days of your arraignment. On down the road, you have the right to a trial and a right to appeal. But for today, we're going to enter that not guilty plea, figure out if you want to hire your own attorney, if you qualify for a public defender, figure out your bond, and figure out your next court date, okay? Okay, hang on one second. You are charged with procuring or promoting use of a minor by electronic means. It's a C felony. I'm going to enter a plea of not guilty to that charge. Right now, the bond is $100,000 full cash to HIP if posted with no social media. And you say you want to hire your own attorney? Okay.
Judge, I apologize. Steve,
Okay.
I believe this was Grant, is that correct, Judge?
Yes.
Okay, I'm gonna enter an appearance in the case at this point in time, at least for the purposes of arraignment only, with the court's permission.
Okay.
Okay, Cindy, I'm gonna enter a plea for you. Do you understand that?
Yes, sir.
Judge, we're going to admit her identity, waive formal reading of the charges, reserve the right to file any appropriate motions at a later time, and enter the plea of not guilty.
All right. We'll enter that plea of not guilty. Note you, at least for today's purposes, Mr. Miller, the bond is $100,000 full cash to HIP if posted. She is a low one.
Could we address the bond issue, Judge?
Of course.
She's been a long-time resident here, Judge, her entire life. She owns property here in town. She has 2 children here in town. She's married. She has her family, her sister, and in all her years, slight risk she is not. She has one charge back about 2006 or 8, a traffic violation. That's the only charge that I know of that she had that represented her back then. So that's the only charge I know of at this point. I realize that the charges are serious, but $100,000, Judge, is a question she could not possibly make that. I would suggest, if at all possible, 10% a lesser amount or that amount.
All right, Ms. Southern.
Your Honor, based on the nature of the allegations, the county would strongly object to a bond reduction at this juncture. We are asking for there to be a written no contact order, and that would be no contact with the juvenile victim, no contact with the place of violation, no contact with any minor children, no social media or electronic devices, and no contact with any JCPS property. Our position, as I said, is that given the facts and circumstances as set forth in the the uniform citation, that this bond is completely appropriate. And we're not disagreeing with Mr. Miller that her prior record consists of a 2008 DUI, but nonetheless, these allegations are extremely serious. There are allegations of certainly contact.
I apologize, was I not correct that the traffic violation was like in 2006 or 8? It's like 15 or 20 years old, 15 years old.
I said I agreed with you.
Oh, I apologize.
Yes.
I didn't understand.
That I said I agreed that there was a 2008 DUI, yes.
I'm sorry.
The allegations here are certainly extremely serious, extremely concerning, related to the alleged contact with the juvenile in question, and then certainly of additional concern are the allegations that there were then not just contact that was electronic in nature, but then arrangements being made to meet the juvenile, and looks like there were actual attempts of picking up that juvenile from his residence, which is where the citation indicates that that's where she was apprehended. So as I said, our position is that this bond is appropriate and should not be changed in any way.
All right, Ms. Graff, I am gonna leave the bond where it is, 100,000 full cash to HIP with no social media and absolutely no contact with the victim in this case. No messages through a third party, no email, snail mail, nothing like that. All right?
Judge, could I ask, can we, the ability to post real property, Judge?
No.
At this point?
Cash only. Correct, Judge? Is that-
Correct. I never do real property.
I'm sorry, you never do real,
I never do a property bond. Always cash. 12/26, 9 a.m.
302.
12/26 at 9 a.m.
Yes, sir.
In which court, I'm sorry?
302.
And then
Thank you very much, Your Honor.
I'm guessing Mr. Miller will be there, even though he said for arraignment only today.
Right. Mr. Miller, did you hear that?
No, I did not, I am so sorry, Your Honor.
Will you be there on 12/26?
Unless there are other counsel, she'll have counsel one way or the other.
Okay,
Okay.
that's all we were trying to figure out. Okay.
Yeah, I mean, she will have counsel there, whether it is someone other than myself or not. I know the family, and that's why I'm appearing.
All right. Thank you. Thanks for clarifying. All right. Good luck to you, Ms. Graff.
Thank you, Your Honor. May I be excused, sir?
Yes.